Hello, my name is Maria Mankelti, graduate in Law and International Relations by IE University and legal advisor. Today, I will speak about the advisory opinion of the International Court of Justice of July 23rd, 2025, which established a historic precedent in the protection of the environment. Introduction. Climate change represents one of the most complex and far-reaching challenges in our time, threatening ecosystems, economies, and human well-being in general. Rising temperatures, extreme weather conditions, and the loss of biodiversity reveal the limits of current legal and regulatory frameworks. Environmental law has become a fundamental tool to safeguard collective interests, promote sustainability, and ensure accountability for environmental harm. Strengthening international legal framework is essential to ensure that states and increasingly private actors fulfill their obligations to protect the planet for present and future generations. Now let's talk about objectives and methodology. This research has three main objectives. First, to analyze the legal scope of international responsibility of states in relation to climate change. Secondly, to study the transition from obligation to prevent harm to the obligation to repair it. And thirdly, to explore how the opinion of the ICJ may influence the responsibility of private actors. This study adopts a qualitative approach. It reviews the main international legal instruments, such as the United Nations Framework Convention on Climate Change, the Paris Agreement, the Articles on Responsibility of States for Internationally Wrongful Acts. Then, it conducts a comparative analysis of relevant cases, including the pulp mills case before the ICJ, the advisory opinion OC 3225 of the Inter-American Court of Human Rights, uh, and the judgment of the European Court of Human Rights in the Klima Signorinen v. Versus Switzerland case. Finally, it incorporates recent doctrinal contributions and scientific findings. ICJ decision. In 2025, the ICJ issued a historic advisory opinion stating that state inaction in the face of climate change may constitute a violation of international law. The opinion establishes that states have both the duty to prevent climate-related harm and the obligation to ensure its reparation when such harm occurs. By recognizing the right to a clean, healthy, and sustainable environment as inherent to human dignity, the ICJ redefines the scope of international responsibility in the context of climate change. Consequences. The International Court of Justice determined that climate change poses a direct threat to human rights and various branches of international law, beyond the Paris Agreement and other international treaties. Although some major emitters argued that Paris Agreement was sufficient to define climate obligations, the court clarified that all states, regardless of their participation in specific treaties, have the duty to prevent environmental harm and protect the climate, emphasizing the importance of acting with responsibility. The court stated that the legal consequences of climate-related harm include restitution, compensation, and guarantees of non-repetition. This means that states responsible for unlawful emissions may be required to cease harmful actions, restore damaged infrastructure or ecosystems, or provide economic compensation. The ruling paves the way also for vulnerable nations to seek reparations from historical emitters for damage caused by climate inaction. Implications for the private sector. The ICJ has not issued judgment directly against the private sector, as its role is to resolve disputes between states. However, this advisory opinion establishes that states have the obligation to prevent significant harm to the climate, uh, and failure to do so constitutes an internationally wrongful act that generates state responsibility. This indirectly involves the private sector, since states must use all available means, including regulation, at internal level to ensure that activities within their jurisdictions do not cause severe climate harm. Now let's talk about the other relevant case law. The case of Argentina versus Uruguay before the ICJ concerned the construction of two pulp mills in the Uruguay River, shared by both countries. The court concluded that Uruguay breached its procedural obligations because it failed to adequately notify or consult Argentina before authorizing the works. However, as no actual environmental harm was proven, no violation of the treaty's substance was found, nor was compensation ordered. The most important aspect, however, of this ruling is that the court affirmed that conducting an environmental impact assessment is an obligation under general international law when there is a risk of transboundary harm. Similarly, the advisory opinion of the Inter-American Court of Human Rights, issued in 2025, sets a historic precedent. The court recognized for the first time an autonomous human right to stable and healthy climate as an essential part of the right to a healthy environment. It establishes that states have clear legal obligations. They must adopt urgent mitigation and adaptation measures based on the best available science, ensure public participation, and guarantee access to information and environmental justice. Likewise, the Klima Signorin versus Switzerland case, decided by the European Court of Human Rights in 2024, marked a historic precedent. A group of elderly women sued the Swiss state for failing to take sufficient measures against climate change, arguing that heat waves endanger their health and lives. The court held that states have positive obligations to mitigate climate change and protect vulnerable people, establishing that climate inaction can constitute a violation of human rights. To conclude, climate inaction is no longer a legal option. The international and national frameworks uh, oblige states to take concrete and effective measures to mitigate climate change and adapt to its impacts. Declarations or commitments are not enough. Uh, International law demands verifiable results and policies consistent with the objectives of the Paris Agreement. Companies, for their part, operate in an increasingly strict regulatory environment where sustainability, transparency, and climate risk management are obligations, not mere voluntary commitments. ESG standard and non-financial regulations reflect this trend, especially at the European Union level. And the cost of non-compliance can be very high. It can be legal due to sanctions or growing climate litigation, international due to a loss of credibility and possible liability before other states, and economic and reputational, of course, as markets, investors, and society in general penalize the lack of climate action. Ultimately, taking action against climate change is not only an ethical and environmental imperative, it is a legal and strategic obligation for both states and companies within their jurisdiction. Thank you very much.